This is ethics in law and public relations. First, let's define some things. Ethical behavior conducts professional activities in a principled manner and adheres to commonly accepted standards for professional behavior. Integrity recognizes and deals professionally with ethical and legal issues. Ethics connotes the process you follow to decide what is right or what is wrong. Unfortunately, most ethical questions do not have black and white answers. Some general principles you can apply to ethics in public relations are: act in the public interest. This means that you find the greatest good for the majority of the people. Using integrity and honesty as your guide, ensuring accuracy and truth. This means do not disseminate false and misleading information, and if you accidentally do make a mistake, correct it immediately with all your publics. This also means to deal fairly with all of your publics. Respect yourself and respect others. When you move to a new position, leave preparatory materials to your old job behind. Now let's get more specific with some more principles that apply to public relations and ethics. You should accurately define what public relations strategies and tactics can accomplish. Do not guarantee results for areas beyond your control. Maintain the integrity of communication channels. This means ensuring transparency with all publics, from employees to external publics. You should also safeguard confidences and make sure that you're not damaging others' reputations to save your own. It's also always important to keep in mind that you should avoid conflicts of interest. This means disclosing interests of yourself and others, getting consent to represent conflicting views, and be ready to publicly identify your clients, sources of information, and funding sources. Here is the 6-step decision-making process that you can follow when you find yourself in a PR ethical dilemma. Instead of reading this off, let's take ourselves through an ethical dilemma, putting yourself in the shoes of a PR director and see how you would handle it. So your role is a director of PR for Megabucks Energy. The situation is Megabucks profits are declining because of the decrease in gas and oil prices. A recent drilling shows a new reservoir for oil in the Java Sea, one of your properties. But geological testing is incomplete and rumors are flying around about the new reservoir. Your boss wants you to write a press release to downplay the rumors and the discovery to get people to stop talking. You find through your research that this is a very huge discovery, and further testing is planned to find out the size of the reservoir. So going through the ethical process, first you want to define the specific ethical issue or conflict. Can you ethically disseminate deceptive information about the financial condition of your company on which the number of key publics may rely? Second, you want to identify internal and external factors. This means legal, political, social, economic, that may influence your decision. What does the Federal Securities Exchange Commission require in such instances? Do federal and/or state laws require a particular decision or disclosure? What do companies' values, policies, and/or procedures require? Next, you want to identify your key values, which are loyalty, advocacy, honesty, and independence. And one of the most important ones I think here is honesty. Consider obligations to tell the truth in advancing the company's interests and in communicating with the public. Next, you want to identify the audiences who will be affected by the decision of the obligation to each. Consider the company/employer, board of directors, state shareholders, potential shareholders, SEC, anybody that might be involved in the decision that will be taking place. Next, you want to select ethical principles to guide your decision-making process. Protecting and advancing the free flow of accurate and truthful information is essential to serving the public interest and contributing to informed decision-making. Maintaining the integrity of relationships with media and government regulatory agencies is essential to public relations practice and in the best interest of the greater public. Truth and accuracy are underpinnings of our profession. Lastly, you want to make your decision and justify it. The public relations practitioner's greatest loyalty is typically to the client. You are obligated to provide counsel and communication support that serves the best interests of the organization. At the same time, responsible advocacy requires that interests of those affected by the decision be considered as well. In this case, numerous publics could both rely on this information and be adversely affected. Although the potential for conflict between loyalty to employer and honesty exists, the value of independence helps resolve this conflict. Sound, objective counsel requires you to refuse to write the release and advise the company on more appropriate actions that don't deceive the various stakeholders or conflict with laws governing the financial disclosure. Ultimately, this course of action is to the company's best interest. Release of deceptive information could contribute to a declining public trust and potential legal liabilities related to proper disclosure under SEC regulations. Your recommended action preserves the integrity of the communications process and helps maintain important company relationships while advancing the free flow of accurate, truthful information. Isn't that just public relations, though? We're just supposed to make sure that the relationship between our client and the public is nice and sound and there is truth in everything. Now, let's move on to law, and this is mostly definitions. Copyright laws have two major goals. The first is to protect the original creator of the work, and the second is to provide economic incentive for the new knowledge. The statutory definition says that copyright exists in the original works of authorship and any tangible medium of expression, from which they can be perceived, reproduced, or otherwise communicated. Common law copyright is an author who creates a tangible definition of his or her ideas and immediately acquires common law copyright for the work. This right continues until the author dedicates the work to the public by a general publication or surrenders common law right to obtain specific statutory copyright protection. Two types of publications exist. General publication is any overt act that indicates the intention to surrender one's right to control one's creative expression and allow the public to copy the material. The second is limited publication, such as delivery of a manuscript to a possible purchaser that does not cause the author to lose any common right laws. Statutory copyright. To obtain statutory copyright, an author must submit copies of what he or she has written to the Library of Congress and display the copyright symbol, that little C with a circle, on the material. Creative expression of ideas is subject to copyright. Securing a statutory copyright is simple. Notice / use of the copyright symbol must be used on the very first copy sold or publicly distributed. Ownership of copyright for photography and artwork. The contract between the organization and a non-employee who takes photos or creates artwork determines who owns the copyright. The copyright owner determines use and the cost of the use of the creative work. Be clear about the ownership of both the negatives and hard copies of photos or artwork in the contract you develop with your legal counsel. The organization owns an employee's work done on behalf of the organization. Defamation is untruthful that damages a reputation. Written or pictorial defamation is known as libel. Spoken or verbal defamation is known as slander and need not to be spoken in a public setting. To qualify as defamation, the statement must be untrue. To be defamed or damaged, an exposed person or organization must prove three conditions were present: hatred, contempt, ridicule. Damage must be proved as well. To be actionable for libel, 5 elements must be present: defamation, identification, communication, fault, damage. Because a public figure puts him or herself before the public, he or she must prove actual malice. Fair comment. A recognized defense against a libel action and is based on the argument that the statement was either true or privileged. Privileged means it was taken from a public document. Be aware that although truth is the traditional defense against libel, truth is hard to prove. Fair comment, which involves privacy, should not be confused with fair use, which involves copyright. Digital Millennium Copyright Act. A U.S. digital rights management law enacted October 28, 1998, created an updated version of copyright laws to deal with special challenges of regulating digital material. Broadly, the aim of the DMCA is to protect the rights of both copyright owners and consumers. Now, to get back to fair use, this principle allows use of parts of copyrighted materials without violating the copyright laws and without paying a royalty or fee when that use is for criticism, comment, news, reporting, teaching, scholarship, or research. Intellectual property. This legal term describes rights or entitlements that apply to the ownership and use of certain types of information, ideas, or other creative concepts in an expressed, fixed form. Foreign Agents Registration Act of 1938. Public relations practitioners working for any foreign principals, whether the practitioners are directly lobbying U.S. government officials or not, must register under this act. The Lobbying Disclosure Act of 1995 relates to the 1938 Act in a broad context by requiring anyone in a public relations or related position who represents a foreign government to register and label lobbying materials as political propaganda. In the New York Times versus Sullivan case in 1964, the U.S. Supreme Court decision said public figures must prove actual malice to win a libel case. Right of privacy. This legal principle, important for public relations professionals to know, ensures an individual's right to be left alone. This right may be violated if names, likenesses, and/or information are used for commercial purposes. Privacy differs from defamation and is a practical effort to protect the individual who does not relish the unexpected appearance of his or her picture, story, or testimonial in the public media. 4 kinds of wrongful acts can violate privacy. Appropriation, taking some elements of a person's name, likeness for advertising or trade purposes without consent. Intrusion, invading a person's solitude, such as audio or video recording him or her without her permission. Public disclosure of embarrassing private facts. The truth is not necessarily a defense here. Medical information, sex crime, victim identity, name of juvenile offender, embarrassing poses, reputation need not to be harmed. And false light, putting a person in false position before the public, misleading the public to make a person appear other than he or she is. Reputation need not to be harmed. And lastly, slavish copying. This term is used for extensive word-for-word copying, so pretty much plagiarism. For an extended review of the law affecting public relations, refer to the AP Stylebook. And that is an overview of ethics and law in public relations.